The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your usually bi-weekly podcast on the Federal Courts of Appeals. I'm IJ Senior Attorney Paul Sherman, joined this week by IJ attorneys Joshua House and Kirby Thomas West. This week, we've got Facebooking jurors, an unpopular church, a very bad cop, and a tire-tapping trespass. Take it away.
So in our first case out of the Sixth Circuit, we have a habeas petition. The petitioner was convicted of first-degree murder for shooting a rival gang member. In spite of, at the trial, he had an alibi, and there was allegedly a confession of the person who actually did it from a jailhouse confession.
He was actually bragging about it at the jailhouse.
Right, correct. So curious, you would think, how this conviction came about, but shedding some light on how the jurors reached their decision. 2 months after the conviction, a juror came forward and filed an affidavit saying that 2 jurors had brought outside information into the jury room during deliberations. And the interesting part of this case is what kind of outside information that was. Specifically, one of the jurors had Facebook stalked the defendant. So the one juror was bringing in information from Facebook. Another juror had Googled gang violence and gang histories and brought in some information about the kind of politics within a gang and what assumptions about where he was in the pecking order and why they might have established this other guy as the fall guy. So when this affidavit was filed, the defendant filed a motion for a new trial, or in the alternative, requested a hearing to at least see if this potentially did taint the jury verdict.
And it seems like it probably had a pretty big impact because they were deadlocked at one point.
Right. The jury was deadlocked, and especially when you take into account this kind of other evidence of the alibi and the other confession, it really seems to have played some role for the jurors. And like you said, after the deadlock, changing their mind. But the court said no, denied the motion for a new trial, denied even a hearing, even though the state had agreed that a hearing was warranted. It was affirmed on appeal because the court said that the information that was presented was duplicative of information already presented.
And just to be clear, at this point, we're still in the state court. So
right.
It's the state trial court, the state court of appeals.
Right. This is in the Michigan State Court. And to the extent that the information was not duplicative, it according to the Michigan Court of Appeals, it was innocuous. So that's how we end up here with a writ of habeas corpus petition. And the parties agree at the point that the habeas petition was filed that the defendant was unconstitutionally denied an opportunity to show that this information prejudiced the verdict. But they disagree to a certain point because the state says no Sixth Amendment violation has been shown because there was no showing of actual prejudice. The problem is because there was no hearing, there was no opportunity for the defendant to show actual prejudice. So though everybody agrees that there was some violation of the defendant's constitutional rights, there was dispute about what the remedy should be. The district court decided that the correct remedy was to grant a new trial. And the Sixth Circuit here, in this opinion, decides that there was definitely a constitutional violation, but the court below had fashioned the wrong remedy. And what should happen is the hearing to try to determine if the information had tainted the jury verdict.
Mm-hmm. And that draws a dissent in this case, right?
Right. The dissent says that the district court had the discretion to fashion a variety of remedies and that the chosen remedy was well within that court's discretion. And I think what you see with the dissent is this tension with habeas cases of dealing with the constitutional violations but respecting federalism and trying to respect the verdicts and the decisions of state courts. And so what the majority is saying is we don't want to infringe too far upon the state court, and what we really want to do is just say, okay, you need to have this hearing, then that was your mistake, not having the hearing. And the dissent says federalism is important, but, the hearing, first of all, this was, I think, 8 years later, so it was going to be very difficult to have that kind of evidence come out in the hearing.
Yeah, one of the questions I saw from the judge was asking if some of the jurors were even still alive. It's possible that some of them are just not around anymore.
Right, and I think when you look at it, trying to pull together this hearing 8 years later compared to having a new trial, I don't know that the burden or the infringement upon the state courts is that much different between the two remedies.
All right. Well, why don't we jump over now to the Fourth Circuit, where we have an interesting Arlupa case involving a church that's rather unpopular in Baltimore County.
That's right, Paul. This actually looked like a simple zoning dispute, but it turned into a pretty landmark religious discrimination kind of ruling from the Fourth Circuit here. So it all starts with a church whose pastor is actually from Kenya or has some ties to churches in Kenya and wants to open a new church in Baltimore County. She purchases a residential piece of property in Baltimore County and wants to put a church there. Her realtor says you can build a church there. And the zoning code actually allows churches as of right in this area. And so the property is bought, the church is built. And when the pastor files a petition for approving this church, the county actually doesn't even oppose the petition at first, but the neighbors oppose the petition. And based on the neighbors' protests at the hearing on the petition, which include statements they made like...
Yeah, they're pretty remarkable statements.
Yeah. The neighbors look like, they were not fans, to say the least, of this church. They were saying things like, the church would include dancing and hollering like they were back home in Africa. Another statement was that this pastor can come over here from Africa and branch out from another church and put all this in our neighborhood. And another statement that they were dancing at the church like it was in Africa, and we don't have that in our block. So these statements clearly displayed animosity towards the church, and perhaps its either religious roots or its African roots, and so
there was also evidence that people were hurling racial slurs at the property.
Yeah. I mean, during this initial opening, I guess, ceremony or church service, there were a couple neighbors who supposedly harassed the church and its members. And there was also some vandalism and theft that they suspected was the result of this community animus. So eventually, the administrative law judge hearing this petition denies it. Now, the petition itself was pretty extreme in the sense that it was actually asking for approval despite the fact that there was absolutely no setback from the street, even though the zoning code required 75 feet, and there was zero parking, even though there are parking requirements in the code. So this first petition is denied. Now, right after that, a second petition is filed that does include some parking and does include a setback. It's not exactly what's included in the zoning code.
It was pretty close, though.
But it's pretty close. And also the zoning code has a second provision that allows for some discretion to the planning commission or to the judge to allow the petition, even if it's not fully up to code, if it's consistent with the character of the neighborhood. So the second petition is filed. It's much closer. And again, the county officials do not oppose it, but the neighbors actually file a motion to dismiss this on procedural grounds, essentially arguing that the dismissal of the first one precludes a second petition for the exact same thing.
Even though the second petition is significantly different than the first petition.
That's right, even though that second petition was different. So it gets dismissed, and the Maryland courts dismiss it as well, or affirm the dismissal, which is what brings us to federal court. The church ends up filing three claims, actually 4 claims if you include their state claim, but the 3 federal claims here are an Arlupa claim, a free exercise claim, and an equal protection claim.
And so for listeners, what is Arlupa?
So Arlupa is the Religious Land Use and Institutionalized Persons Act. It's a statute that was passed around the year 2000, and it concerned two topics, as you can tell from the title. One is land use, and then the other is institutionalized persons, that is people who are in prison. And it concerns the religious freedoms of both of those. And what it does is it basically says that if a government action discriminates on the basis of religion and creates a substantial burden on religious practice for people of religious faiths, that the government has to have an extremely good reason, a compelling interest, in order to put that burden on the religious practice. And so as applied to the land use context, that means that applies to people who are zoning, who are looking for zoning variances, churches that want to build in neighborhoods that sometimes cities don't want to let be in their community because they're tax exempt, or a variety of other reasons, traffic and whatnot. So the government's got to have a very good reason for doing it. all three of these claims, importantly, concern religious discrimination. So the key issue in this case, there's a bunch of sub-issues, but the key issue here was whether there was any discrimination on the basis of religion in this case. Now, of course, the government argued that there was no discrimination, that this was just the rote application of the zoning ordinances and things like that. And the court ultimately, disagrees. Now, this is just on a motion to dismiss. So what happened in the trial court was that the federal trial court just kicked the claim, saying they didn't even allege discrimination. But the Fourth Circuit Court of Appeals here says no, they did allege, based on the complaint, a religious discrimination. And the court does that in actually a pretty novel way, which is it says that the discrimination can be shown, the government's discrimination can be shown by the statements of the community members that were made at the hearing, and that you can essentially infer government bias based on a community's bias. And the way it does that is it actually says that you can look for signs like procedural irregularities to show that the government has been influenced by the community's kind of xenophobic or anti-religious views. So the court goes through the facts as alleged in the complaint here and says, look, there were a lot of procedural irregularities. Obviously we know about the statements and the behavior of the community. And then following that behavior, you had, for example, the denial of the first petition, even though the government's own planning expert didn't want to deny it. And in the second petition, you had the county's legal expert not opposing it, and yet still dismissing based on the community members' motion to dismiss on these mere procedural grounds. And the court says that both of these procedural irregularities actually show that the government had been influenced by the views of the community members.
So this is really interesting because, in a lot of the cases that we deal with under the rational basis test, what courts basically say is you can never figure out what's in the mind of a government official. And so we will never kind of engage in that inquiry. And this seems to be the exact opposite of that.
That's right. Yeah, the court is really kind of pulling the curtain back and saying the government can't just rely on kind of mere procedural things to say it didn't have any bias, that it was just following the rules, when all of this extraneous evidence, including the views of the community members, actually did show some bias within the community.
What a difference a standard of review makes.
I mean, that's right. Although, this technically was going in before this inquiry is actually happening, before the compelling interest, narrow tailoring, kind of strict scrutiny that's going to happen later. In fact, this is the test about whether or not that higher standard of review is even triggered. So it's interesting that the court, was still willing to kind of get into the nitty gritty even before it decided it needed to get into the nitty gritty.
A case that sounds like it'll have some possibly pretty significant implications for other cases down the road.
I think certainly for the religious discrimination context, and perhaps even for other contexts where the government's motives are at stake.
Great. Well, why don't we jump over to the Eighth Circuit and a case about a very, very, very bad cop.
Yes, we're turning to a very sad case out of the Eighth Circuit. And this case involved the killing by a police officer of a 15-year-old boy during a response to vehicle break-ins in a parking lot. So we start with this police officer who just has a truly outrageous history. He was hired in 2006. During his interview, it came out that he had attended a KKK meeting in high school. This is in 2006. This fellow had attended a KKK meeting somewhat recently. He explained it by saying he wanted to see what his friend's grandfather did, so he just was going to check it out. There were also some irregularities on his polygraph during the interview process, but he was hired nonetheless in a 3-1 vote over a dissent in which, the vote against him, that person had said, we have some serious concerns about this guy's maturity and judgment, which I think is an understatement. But going on into, his 5-year career before this case arose, he just had a very long list of disciplinary actions, from failure to activate recording device to sleeping on duty, failure to properly investigate, failure to follow orders, just goes on and on.
And beating up a lot of people, it sounds like.
And getting to that too. So we have 3 triggers of the early intervention system alert, based on a very high number of use of force incidents. and a citizen complaint about a use of force incident. And then all of this leads up to, not even this case, another incident in which he was accused of untruthfulness and dereliction of duty when he was called to a break-in at a store. And he told the officer who had sent him that he had responded, and he had gone and checked the door to make sure that it was locked.
Unfortunately for him, there was security footage.
Right, there was security footage that kind of contradicted his entire story. So,
in fact, it just showed his car rolling on past and never stopping.
Right. So his checking out and responding to this break-in in which somebody had actually robbed the store and thrown a stone through the window and robbed the store, he just drove by and kind of checked out the window to see what was going on. So all of this predates this case, which it started in 2012. He responded to a call about vehicle break-ins in a parking lot. And when he got there, he says that he saw 3 individuals that were looking into cars with flashlights. And when he approached them, they got into a vehicle and started driving towards him. And he says that he was afraid that they were going to run him over, and that he said, "Police, stop." And they continued driving toward him. So he shot into the driver's side, killing this 15-year-old boy. Again, like the break-in incident, all of the other evidence contradicted his story. So the two other boys who were in the car said that as soon as he said, "Please stop," the driver had stopped and was in the process of trying to reverse the car when he was shot. And the physical evidence on the scene backed that up. The car had no damage underneath, which if you believed his story of where the car had gone, it would certainly have had. And the area that he said the car had driven after when he had shot the driver was completely undisturbed. So, all of the evidence shows that the boys were right when they said the car had stopped and was about to be reversed when the driver was shot. He was arrested for manslaughter and was fired, thankfully, from his job on the force. And the boy's mother then sued in a 1983 suit and brought the claims against him personally, against the police chief for hiring him and negligently supervising him, and against the city.
So the 1983 lawsuit against him sounds like a slam dunk.
Yeah, and it was. That one went to trial, and the jury awarded over $400,000 to the mother. Unfortunately, this is an individual lawsuit against this officer, a police officer who's been working for 5 years. So, query how much money of that $400,000 the mother would actually collect. The claims against the police chief and the city, however, were dismissed before proceeding to trial. And she, appealed these, and that's where we are in this case. And so this case, we're dealing with municipal liability. Under a 1983 suit, when you sue an individual, so you're bringing a suit under 1983 for constitutional violations by government actors. If you're bringing it against an individual, it can be related to one constitutional violation. If you're bringing it against a municipality, you have to be able to show a policy or a custom that resulted in the injury. So like pattern and practice of constitutional violations that led to this specific one.
And this is very different from sort of individual tort lawsuits. So for example, if an employee of a company in the course of doing his business injures me, I can sue the company and the company can be liable for that. But with municipal liability, you have to show that there was some kind of policy that that resulted in the employee injuring you.
Right, which, as you just say that, it seems a little incoherent because it is. The government is benefiting from the services of this police officer the same way that a private employer would benefit from the services of their employee, and placing the responsibility on them for misconduct of their employees makes sense, and having them kind of be on alert that they have to take precautions about who they're hiring and how they're treating the people that they hire, and trying to, make sure that they're not causing some kind of danger to the community. But unfortunately, in the context of the government, it's very hard to recover from a municipality, and that's exactly what happened here. The mother brought a lot of different claims about theories of misconduct and policies, consistent failure to investigate police misconduct, or a pattern of shooting at moving cars. She wasn't able to show any of these theories that she had. And so the court says here that there was, no municipal liability for the city. There still is a claim then against the chief of police for a poor hiring decision and for inadequate training and supervision. Those are also dismissed. The showing liability for a hiring decision is very difficult as well for a government actor. You have to be able to carefully test the link between an adequate decision and the alleged injury. So basically what the court says is, it wasn't plainly obvious that this person was going to unjustifiably use deadly force from his interviewing process. So you couldn't show that there was liability for a hiring decision, which is an insanely high standard. If it was plainly obvious that a police officer is going to unjustifiably kill somebody and you hire them anyway, I mean, that seems like you should have more than just liability in a civil suit. You're insane.
Yeah. That seems like you should be in jail if you do that.
Exactly. But not so here. That's the standard that we're dealing with. And then inadequate training and supervision, similarly a very high standard. And the court says, look, he was a terrible police officer, but it wasn't enough, basically, to show that there was inadequate training and supervision.
Wow. Well, as high as that standard is, it's still an improvement on what things used to be, because the case that established this standard, Monell, actually reversed an earlier decision that said that municipalities actually just weren't covered by Section 1983 at all. So at least now you can sue municipalities, but as you say, the standard is very high and it can be extremely difficult to win, even in cases with pretty outrageous facts.
Right, yeah. It's a great point.
Well, let's jump over to the Fifth Circuit for our last case with a tire-tapping trespass.
Yeah, this case, really does develop the kind of post-U.S. v. Jones Supreme Court, decision about the Fourth Amendment, and really changes the law a bit in the Fifth Circuit.
And so, before you go on, what was U.S. v. Jones?
Yeah, so U.S. v. Jones was the Supreme Court case that concerned the placement of a GPS tracker on a vehicle, and the question was whether or not that was a search under the Fourth Amendment. And the court said it was, because the placement of that GPS tracker was essentially a property trespass. The truck was the property of someone else, and by placing that object onto the property of someone else, there had been a trespass, and therefore it qualified as a search.
That was a big reversal from the way the Supreme Court had been approaching these questions about whether something was or was not a search.
That's right. While there had been some property trespass decisions back before the 1930s, there was a very famous Fourth Amendment case called Katz, and that concerned, believe, telephone eavesdropping, wiretapping, and whether or not the government needed a warrant to do that. And really, what the court since then has focused on is whether or not there's an invasion of privacy, and whether or not someone had a reasonable expectation of privacy. That's kind of the standard that courts have used. And what the Jones case did was kind of reset it back to the kind of property question. It didn't actually overrule the reasonable expectation of privacy standard, but it kind of adds this other way in which things can become a search.
Okay, and so that brings us to this case.
Right, so that brings us to this case. There's a truck that's moving south in Texas toward the border, and the policeman pulls behind it and notices that the car is veering. It notices that the tires are wobbly, and so the policeman initiates a stop.
Mm-hmm.
And
before you go on, one of the interesting things about this is ostensibly what the police officer stops the driver for is crossing the fog line, which is like the solid line that separates the lane from the median, which is just one of the things you learn as soon as you study any Fourth Amendment law is that if the cops want to stop you in a car, they will find an opportunity to stop you, because even the tiniest infraction, or even just the allegation that there was an infraction, because we have no proof that she actually crossed the fog line, is enough for them to pull you over.
That's right. I mean, if you look at the list of things, I think the policeman was very thorough with his reasons for the stop. There was supposedly a taillight out that he noticed once it started braking as well. So there were multiple reasons, I think, that any qualified policeman could have found to stop the car. But in any event, the car is stopped, and the policeman then begins to approach the window. And as he approaches the window, he taps or presses on one of the tires. and notices that it sounds like it's full of something. It's not quite hollow like a tire is. Then proceeds to talk to the driver, who claims that she's moving to Brownsville, Texas, with her husband, but she's extremely nervous at the time. Her lips supposedly were covered with some sort of white powdery substance. The vehicle was just registered, despite it being an old beat up pickup truck. So there were all these things that
he also claims that the lug nuts on the tire look like they were. He's a very kind of Sherlock Holmes character, like just taking in and processing all this information, which leads him to suspect there's something in the tire.
Well, like I said, he was very thorough, and after all of this, and after running the plates and everything, the policeman asks the driver if he can do a search of the car, and the driver consents to the search.
Let me interrupt again. You see this again all the time in Fourth Amendment cases. Drivers always consent to these searches, and just a tip for our listeners: never, ever, ever consent to a search, particularly if you're in the situation that this driver was in.
Yeah, I mean, obviously, don't talk to the cops. You hear that all the time.
Yeah.
Probably a good idea not to consent to searches as well. Get a lawyer. But in any event, the driver, consents to the search here, and the policeman, after letting some air out of the tire and smelling something funny, decides that he's going to have to take the car in to get further search, and of course he does, and the shop he takes it into discovers a bunch of things in the tire, little storage compartments where there are methamphetamines. And so the driver of the vehicle is eventually charged with drug trafficking. And one of the issues that arises during the case, and that's the issue of this case here, is did the tap on the tire of the car prior to the consent of the search, was that an unconsented, unreasonable search in violation of the Fourth Amendment? And the court here actually decides that yes, that was a search, that tap on the tire of the car. And as we talked about earlier, it did so under this property trespass approach. And it basically said that if the touching of a vehicle to place a GPS tracker on it was a trespass, then the touching of the vehicle to essentially inquire as to whether it contained methamphetamines or some other drug substance was a search under the Fourth Amendment. Now, but the court actually went on, though, to discuss whether or not a warrant was necessary. And there's a really interesting discussion about whether there was probable cause, because if there's probable cause, then, of course, a warrant wouldn't have been necessary at the time.
Yeah, well, and this is because there's a rule called the automobile exception. So the idea is that cars are mobile, and so if you required police officers to get a warrant before they could search a car, the car would drive away, it'd be gone. So if you're in a car, you have fewer Fourth Amendment protections than if you're, say, in your home.
That's right. And this really interesting discussion about probable cause, first the court says, well, was there probable cause for drug trafficking, which is what she was eventually charged with? And the court actually says no. It recites a bunch of those facts that the officer had talked about. It recites the wobbly wheels, the stripped bolts on the wheels, the nervousness of the driver of the car. It cites all these facts. And then says that's not enough. That's not enough to establish probable cause for drug trafficking. But it says there was probable cause for a vehicle safety violation. Essentially, the wobbliness of the tires, as well as the veering of the vehicle, suggested, or at least were enough to establish probable cause that there was a violation in terms of the vehicle's road sturdiness, and that a policeman can tap on the tires of a car to ensure that it is road safe, and that therefore there was probable cause for that search. So that's really interesting because a lot of times, as we talked about earlier, you'll see the police layer on these suspicious facts in order to build up not only reasonable suspicion but hopefully probable cause so that they don't need a warrant. And the court says no, those suspicious facts were not enough for drug trafficking. But it just so happened here that the vehicle didn't look roadworthy.
Mm-hmm. One of the interesting things is they talk about the intent of the police officer in touching the wheel and whether that makes it a search. So, for example, if the police officer had, dropped his flashlight and reached down to get it and then steadied himself by putting his hand on the tire and then felt something was funny about the tire, that would not be a search. But if he's touching the tire specifically for the purpose of divining information about what's inside it, that is a search, which I think raises interesting questions about, are we going to start to see police officers saying like, oh, I dropped my flashlight and I just steadied myself on the tire?
Yeah, I think the Fifth Circuit here is realizing that this is a really hard and fast black and white rule, this property trespass doctrine, if touching is a search. And so I think that they do two things. One, of course, that they couch it in kind of realistic situations and say, look, the search has to be an intent to search. It has to be an intent to find information. So if the policeman just walks up to the door of the car to write you a ticket and leans on the door of the car, that's not a search, because they're not leaning on it in order to find something. They're doing it to write the ticket. So they kind of couch this holding in that kind of recognition. But they also recognize another thing, which is that this property search doctrine is simplistic, but it's simplistic by design. It's simplistic because simplistic rules are easy to follow, both for officer and for citizen, as well as for judges. And it says that even though it gets us into these inquiries about whether or not touching is searching, that as picayune as these controversies sound, they're important because hard and fast rules do have value in the legal system. And
this is actually a rule that IJ is currently trying to apply in a challenge to food truck regulations in Chicago, Illinois, where the city requires you to have a GPS device mounted on your food truck. And we have argued that constitutes a Fourth Amendment search and that it's not reasonable.
That's right. And this case actually does show that there's a lot of development happening in the courts of appeals following the Supreme Court's decision. Notably here in the Fifth Circuit, there was a case from, I believe, the late 80s or early 90s, the Muniz-Melcher case, which actually concerns tapping on a gas tank, a propane gas tank, to see if there was something inside. And back then, the court said, no, that's not a search.
You have no expectation of privacy that, say, someone at a service station is not going to accidentally tap the propane tank.
Right. And so what this case shows is that the court, that decision clearly has been abrogated by this decision, and it's done so under this U.S. v. Jones case. So it shows that, IJ's claim in the Chicago case and other claims similar around the country might have, a lot of legs as the law develops in this area in response to the Supreme Court's ruling.
Well, as the law develops, you can be sure that you're going to hear about it here on Short Circuit. Thank you so much for joining us. We hope to have you join us again. Until then, this is Paul Sherman extolling you to get engaged.